The person logged on with the iPhone, can you unmute your device? Oh, it is running. Phone says ready for you, but you were talking, so I'm. He always, yeah, he's there. He's always. He was in that framework, Judge. Okay. All right, we ready on, oh, Miss Christian had to go pick up her grandkid. Do you have a number, Judge? Miss Christian? This is, CR438. Your attorney is not here. Okay, Miss Christian is parking and going into the house. She had to get her grandkid. Miss Coakley.
Yes, good morning.
Good morning. You have a case today somewhere?
Yes, with just Sabree?
Is it a landlord tenant case?
Yes, ma'am.
Okay, so that's courtroom 436 with Adam Sabree. This is a felony matter.
Okay, thank you so much.
Okay, while Ms. Christian is logging on, do you all want to discuss a date, for example?
Yes, we can do that, Your Honor.
Okay, Attorney Peterson, do you want to do the same day as your other exam? Or do you?
That works for me. That would be easy.
Okay. Now, I forgot, I don't have the file when I said the other exam.
It was April 24th at 1:30.
Okay. Thank you.
That date would be good for me, Your Honor.
Okay.
Would you mind putting your email in the chat so I can get you discovery too?
Okay.
Got it.
Thank you.
Okay, we have everybody present. I'm getting ready to call Ms. Diana Christian. Okay, this is case 2355302, the people of the state of Michigan versus Diana Christian. Ms. Christian is charged with one count of conducting criminal enterprises set for a probable cause conference today. Appearances.
Good morning, Your Honor. Alex Peterson on behalf of the people, P 80971.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P 31383, on behalf of Miss Diana Christian.
Ms. Christian, can you state your name for the record, please?
Diana Christian.
And Ms. Christian, thank you for being patient. You've been here, this is your third time coming to court this week. Because of other appearances and confusion, just appreciate you showing up without any attitude and just being patient, so thank you.
You're welcome.
So, while you were, we were waiting on you, Ms. Christian, the Attorney General's office and your attorney, we set a date, or we discussed a date. It'll be the same date as, I believe it's your sister, Ms. Tamika Christian, so it'll be April 24th at 1:30 p.m. for the exam date. Okay?
Okay. Okay.
Is there anything else we need to discuss on the record?
I just briefly sent my information to the AG regarding discovery, so I'll expect to see that very shortly.
Okay.
I'll get that over. Thank you.
Okay, Ms. Christian, so it'll be in person, preliminary exam, April 24th at 1:30 p.m., okay?
Okay, thank you.
You're welcome. You all have a good day.
All right, thank you. Have a nice day, Your Honor.
Thank you.
All right. Thank you.
Attorney Hart. You looked in the system and said that it was a fifth date on there, Ms. Parrish, the last time.
Attorney
we were in here.
Visconti,
Good morning.
good morning. What did they say? You have a landlord tenant case?
I do. I have two for Aaron Cox's office.
Okay, so that would be in my brother's courtroom.
I'm sorry, what is that courtroom number?
It's 436, so.
436? Okay, thank you.
You're welcome.
Everybody subpoenaed for today. Everybody subpoenaed from you. Or was it not? I guess. You know. That's just, I'm guessing, but I mean. You like, you went. I mean. Defense counsel. I may ask you. I just, no, just. I figured out, because yesterday there was another time here, but he didn't feel like that.
That's the only reason. I didn't hear from her. She took the judge. We had a fifth date. So she said, we'll just hold on to it. Because she can't do it. But it was a lot going on, so, you know, I'm no, but it's okay, because the judge said she just.
I know. I think I raised that.
No, it's okay.
After the day is done, I'm gone.
Okay, we're on the record as the people of the state of Michigan versus Reggie Jewel Winston, case 1956101. Mr. Winston is charged with one count of controlled substance, delivery, manufacture cocaine, heroin, or another narcotic less than 50 grams, with the second or subsequent offense notice, and also a habitual offender's second offense notice set for a preliminary examination today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Romy Mezzi, P68245 on behalf of Mr. Winston, he's present for a preliminary exam.
Mr. Winston, can you state your full name, please?
Reggie Joel Winston.
Good morning. Are all parties ready to proceed?
Your Honor, my apologies. People are unable to proceed at this time.
Your Honor, as the court knows, we've been here a few times. My client wasn't incarcerated, he's out now. I've received absolutely no discovery in this case. This is an old case, almost 4-year-old case. We're prepared for an exam regardless, and I would move for dismissal.
Okay, the people are not ready to proceed based off of,
Have any discovery?
okay. All right, so with that, I will dismiss without prejudice.
Thank you, Your Honor.
You're welcome.
Have a great day.
You. I never responded. Thank you. Oh,
Do we have any updates on 9:30? And that one I believe
she's back there talking. She's talking. She's back there talking.
okay. Oh, okay. Thank you.
We ready on? The vote?
Yes, yeah.
Case 2355865, the people of the state of Michigan versus Antoine Terrell Bolden. Mr. Bolden is charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, and obstructing set for a preliminary examination today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor, from Law Rather than yes, on behalf of Golden, P85465. Mr. Golden, if you could state your name for the record.
Good morning. Are all parties ready to proceed?
Yes, Your Honor.
Yes.
Okay, if there's anyone on YouTube who may be watching or on Zoom who may be witnessing this case, now is your time to log off. There's no one in the courtroom who is witnessing the case, to my knowledge. Is that correct?
Correct, Your Honor.
Okay, that you call your first witness?
Thank you, Your Honor. People call Officer Deshaun Perry. Thank you, Your Honor. Good morning, officer. Can you state your name for the record, please?
Deshaun Perry,
Officer Perry, could you please tell us where you're currently employed and what capacity?
the Detroit Police Department, police officer.
How long have you been a police officer, sir?
3 years.
Were you employed in this capacity on March 8th, 2023?
Yes.
Were you by yourself or with partner that day?
I was with 2 partners,
Do you recall their names?
Officer Funnel and Officer Biggs.
Were you in a full or modified uniform on that day, sir?
I'm modified.
And what does that entail?
Black outer carrier with a Detroit police on the front and the back and green vest.
So it have police officer markings on it?
Yes.
And were you in a scout car that day, sir?
Yes.
Was your scout car fully or semi-marked?
Fully marked.
Pardon me?
Fully marked.
Okay. And to ask, do you recall, were you the driver or passenger in that vehicle that day?
Front seat passenger.
Did your duties as a police officer on that day take you at or near 14530 West McNichols in the city of Detroit, County of Wayne?
Yes.
You recall what's at this location, sir?
Green light location.
Pardon me?
Green light gas station.
Gas station, okay. And, sir, can you tell us why you're at or near that location?
Providing special attention to that green light gas station.
While at or set, near said location, did you observe something that drew your attention?
Yes, I did.
And what was that, sir?
While inside the parking lot, I observed the male walk outside of the gas station, from inside of the gas station out to the parking lot, with his right hand in his hoodie pocket, holding what I believe to be a firearm.
Okay. And why did you believe this to be a firearm that you observed?
I saw the imprint of it. I had my partner, bounced me part of my observation, and I had him put me closer to the male. Once he put me closer to the male, I could clearly see that he was holding a firearm in his pocket.
So, sir, would you be able to identify this person if you saw them again today?
Yes.
Is that person in the courtroom today?
Yes.
Could you please tell the court where that person is and the article of clothing that they're wearing?
Sent by the defense counsel, wearing a black shirt.
Your Honor, may the record please reflect the identification of Anton Walton, the defendant? So reflected. Thank you. Officer Perry, after you observed the defendant and what you believe to be a firearm on his possession, what if anything did you do with that observation?
Yeah, I bounced my partners in my observation, and after the officer come and put me closer to the mill, I engaged him and I asked him what was in his pocket. Really just giving him time to produce a CPL, because if he was a CPL holder, I wasn't gonna, get out the car and risk it.
Okay.
After I asked him what was in his pocket, he stated nothing. And at that time, I knew, that was nothing.
What did he state, sir? I'm sorry.
I asked him what was in his pocket, and he said nothing.
Okay.
And I was about, before I get out the scout car, he fled on foot.
He right after he said nothing, he fled on foot?
Yes, I was getting ready to get out the car, and then he took off running.
Okay. Once the defendant started running, did you give him any commands?
Yes, he took off running, and I asked my scout car and pursued him on foot, giving him several commands to stop running.
Okay, did at any time he complied with these commands?
No, not at all.
Okay. Did you continue to pursue him?
I did.
During your pursuit, did you observe anything?
While running, he started running towards 6 Mile. He took his right hand out of his right pocket, and at this time he was holding a black firearm, like semi-automatic firearm in his other hand while running.
Okay, so you actually observed the weapon that you had initially believed to be a weapon in the imprint?
Correct.
Okay, and I'm sorry, could you describe the weapon for us again?
Yes, like I said, it was like a black semi-automatic firearm.
Did you eventually catch up with the defendant?
I did.
Okay. Were you able to apprehend him when you caught up to him?
I did.
What happened after you apprehended him, sir?
Detained him in handcuffs, placed him in the back of our scout car, and I backtracked to that firearm and found it approximately like 10 feet from our detained him at.
Okay, so to clarify, when you apprehended him, did he have that firearm that was once in his right hand as you described still with him?
Not with him, no.
Okay. So, and sorry to cut you off, so after you apprehended it, you said you went back to recover the weapon, okay.
Correct.
So where did you recover this weapon, sir?
Like I said, maybe 10 feet from our detained him at.
And how are you confident that that was the same weapon?
Because I saw it in his hand while he was running.
And was it the same weapon that you had saw?
Yes.
After recovering the weapon, do you recall the type of weapon it was after you, once you recovered it, sir?
Yes, it was a black Taurus G2.
Okay. Was, do you recall if the weapon was loaded?
Yes,
It was?
it was.
Okay. In the course of your investigation, did you have an opportunity to confirm whether the defendant was a valid CPL holder?
Yes, I identified him, and he's only 20 years of age at the time. Not legally allowed to conceal a firearm.
Okay. And so at 20 years old, you can't legally have a CPL, correct?
Correct.
So in the course of your investigation, did you have an opportunity to find out whether that weapon that you recovered was registered to anyone?
I did.
And was it?
Was.
Okay. Was it registered to the defendant?
No.
Was it reported stolen?
It was not. It was registered to the person that he was staying with at the time.
Okay, so it was registered to someone in the same household as his address?
Correct.
Okay. As the defendant's address, let me just clarify that.
Correct.
How did you learn of this? Did you, if you wouldn't mind?
So the defendant is he has a out of state ID, and it took me a long time to identify him. So we went to his address that he was currently staying at, which was like down the street. And come to find out when I run that address, when I run a firearm, that it came back to that same address where his ID was at.
Okay.
I think I would object just for hearsay from the content of the search. What is it, you're saying, what's the hearsay?
That he's relaying the content of the search rather than contact with someone that lives in the house or information.
Search of the register of the gun?
Your Honor, I would indicate that it is not hearsay, as that is a machine and not actually a person. As you know, hearsay must be a declarant, which must be a living person, not a machine or an animal for that matter. Therefore, it would not be hearsay if Mr. Officer Perry did run the registration of the weapon and find out who it's actually registered to.
So a person does input that information.
Pardon me?
That a person input that information to me. So it's
Yes,
not-
but it technically is not hearsay, Your Honor, and regardless, if a person, just like, basically, if, you know, obviously all of these machines, people run them, but a machine technically is not hearsay, just like a radio, somebody actually puts the music on and people hear it, but it
The
is
music
not.
comes from somewhere.
Pardon
So
me?
I'm going to overrule the objection, but the response that it's a machine, it's a database where information is
Correct.
entered to the database by human beings.
Right, and it, there is no case law that indicates that lien or registration or any has ever been deemed by Supreme Court or an actual case law indicating that this machine that officers use and other people actually use as well to find out registration, people's actual lien, any type of item that is coming out of these machines is not deemed hearsay because of the fact that that actual, how they obtained it was not a declarant.
It's a database, not a machine.
The database is not a declarant, Your Honor. And there is no case law that indicates it ever has been.
I overruled the objection.
I'm sorry?
I overruled the objection.
Oh, sorry, I thought you wanted me to still go on about the, okay. Thank you, Your Honor, my apologies. The weapon that you observed with the defendant that you indicated that you recovered, was that placed into evidence, sir?
It was.
No further questions, thank you.
Cross.
I'm going to join the Zoom, just in case, I need to.
I'll make
So, when you were giving special attention to this gas station, does that mean that there's no particular reason that you came there that day? Just as on your schedule to do that?
Correct.
Okay. And you were in the car during your observation of the area of the gas station?
Correct.
Okay, observing through the car window?
Yes.
And this took place at night, or at least when it's dark out?
Yes.
Okay. When you observed the person walk out of the gas station, he was wearing a black hoodie?
Yes.
Okay. And you were on. Had to make sure I was even. And you were maybe several car distances away from that. Is that fair?
Sure.
At a different end of the gas station parking lot than he was at?
When he first came out, I was directly in front of him. Maybe,
Directly in front of him?
like maybe 20 feet away, 30 feet away.
Okay. And you were present in person at that gas station, obviously, so you would be able to recognize it again today?
Yes.
Okay. I am going to share the green light footage from that day, if I can. So this is the gas station parking lot. The car is not visible on the initial frame. So,
That is the side of the gas station. The front door is where he walked out of when we first saw him.
okay, the car is parked though out of frame by the pump that you can't see. Is that correct? That's different to me. Or where
Scout car?
The scout car, that's correct. Where was the scout car parked relative to what you can see in this frame?
This is, like I said, the side of the building. The front of the building is around that. He's in front of the building. The front door, this is the side of the building.
Okay.
Because that alley leads to the back of the building. That's where he ran. He came from the front of the building.
Okay.
So when he came out the front of the building, he made a hard right and is trying to make it to that street.
You're not responding to questions now. You could just respond to the questions rather than extemporaneously explain them.
Excuse me?
If you could just respond to the questions asked rather than extemporaneously explain, that would be great.
I was doing it for him, so.
So at this point, you can see the back of someone, right? And you're, based on your explanation, you're on the other side of the building, so you would be behind that person at this point,
I'm on the side of him at this point.
on the side. Okay. So the car approaches him from the side, right? The scout car approaches him from the side, is that right?
At this angle, yes.
Yes, okay. And then the scout car enters, I'm not sure what the terminology is for it, but the curb cut where you would normally be able to exit the gas station parking lot by car. Is that right?
Sure.
Right. He's attempting to walk on the sidewalk, which would also be a normal foot path out of the gas station.
He tried to, yes.
Okay. At which point the car blocks Mr. Golden's path.
Correct.
Okay. At this point, you had said to him just one question.
The only question I asked him was that in his pocket.
Okay. And then you begin to open the car.
Correct.
Okay.
Are you ready to enter?
I am, yeah. Thank you, Your Honor.
Your Honor, I would object, we saw a little bit more sheet goes into that, but I mean, if we're gonna enter this, video, was there something more to be shown?
Well, after she enters it in the evidence, I want to ask if you publish the report in its entirety.
Thank you.
I would ask if that be admitted into evidence as defense exhibit A.
Any objection?
No, you're. As long as the rest is like the introduction.
Okay. And can you clarify, Attorney Warren, are you starting from, or what point you starting back at?
I was going to start from the point that we had stopped, but it's a 1-minute video, so I could begin the video again.
That would be, okay, great.
So in that video, the time between when you engage Mr. Golden verbally and when you get out of the car is extremely short,
Correct.
less than a second,
All right,
or around a second.
thank you.
And you said on direct examination that you were giving him time to produce the CPL.
Yes,
Okay. But between the time that you initially engaged him and you got out of the car, that time to produce the CPL was less than a second.
maybe, I'm not sure.
Okay.
So when I said I was giving him time to produce the CPL, I knew what was in his pocket, and I was expecting him to say, I'm a CPL, or something along that line. He didn't.
Okay. Okay, from there, you indicated on cross that you were giving, or sorry, on direct examination, that you were giving verbal commands to stop and that Mr. Golden did not listen at all.
Yes.
Not at all. Were you aware that the total amount of time from when you exited the car to when Mr. Golden was apprehended totaled 38 seconds?
Okay.
Not an extensive, but
He had more than enough time to stop. He could have stopped the first time I said stop.
And you said that your commands were to stop running.
Stop, I say stop, stop.
Do you recall saying, stop, I'm about to tase you?
I said stop or I will tase you, yes.
I'm going to read again. You were wearing body cam that day?
Yes.
Okay. I know it's hard to recognize because it's looking at the cement floor right now, but does that look like the body cam that you were wearing that day?
I can't tell.
Can't tell, okay. But the court allow me to play a few seconds of NWI.
It looked like my body cam.
Okay. Okay, so that is your body cam. I'm going to restart so we can hear it more clearly. So that is your body cam. I'm going to restart so we can hear it more clearly. So that is your body cam.
Got feedback from your
I
husband?
know. I can't hear.
Feedback from about time.
Oh, thank you. I'm sorry. So did you hear in that, you say, stop, drop that gun, you better drop that gun, I'm about to tase you?
Yes, that's how I feel.
Okay, and there was no or included in that statement.
Maybe not, no.
Okay, there was no alternative.
The alternative is I would say I would shoot him. I did not want to do that. So I said I would tase him.
Okay, I mean that there was no, you did not convey that if he stopped or if he dropped the gun, you would not tase him?
I was in the middle of a foot pursuit with an armed individual.
Okay. And you were in foot pursuit, so you were located behind Mr. throughout this interaction.
That's how that works, yeah.
Okay. And you can see from the video at least that it is dark. Is that correct?
Yes.
Okay. On direct exam, you said that you were able to identify that he had a black weapon in his hand in this level of lighting from behind while running.
Yes, when we first started running, his hand was in his pocket. When we got closer to 6 Mile, he pulled the firearm out of his pocket.
Okay, and you said that that was his right pocket?
Yes.
Okay, but at the beginning of the direct exam, you said that it was the front right pocket?
His right hoodie pocket.
When you apprehended Mr. Golden, there was no weapon on his person? And he didn't make any statements indicating that there had been a weapon on his person?
Actually, he did. So when I finally detained him, I immediately began looking for the gun, and he made a statement advising that it was across the street. So I, like an idiot, I ran back across the street looking for a firearm that I knew he had in his hand, in his pocket. Come to realize that the firearm that I found was actually closer to him across the street.
That firearm was registered to another individual.
You want to give me one?
Okay. That firearm was registered to another person, right?
Yes.
And was not recorded stolen at any point?
No.
Okay, and as you said, you were on 6 Mile at that point?
Yes.
No further questions.
I just want to clarify a couple things. I believe I understood on direct, but maybe got a little confused on cross. So when you indicate on direct, you stated your thought of what the defendant may do after you inquired about the weapon. Now, and then I know you kind of went back and forth, and what I'm basically trying to ask is, you could clarify for the court, when you indicate that you thought that perhaps he may tell you he's a CPL, so you want to give him an opportunity to indicate that? Was that your thought? And if it was, when did you think that? Before or after you asked him if he had something in his pocket?
So when I engaged him and I asked him what was in his pocket, I already knew what was in his pocket, or I had a belief what was in his pocket. And at the time, there was 3 of us in the car. I didn't want to get out my scout car and approach a CPL holder, because sometimes it feels aggressive. When you're a law-abiding citizen and you have a CPL and you have 3 people walking up on you, it seems like, a bit much. So I'm gonna give you a chance to produce your CPL before I get out the scout car.
So when you say you want to give a chance, are you basically, so that's the reason why you asked him what's in your pocket? You just said that you knew, but you asked him that in hopes that he would tell you he's a CPL.
Correct.
Okay, and I just wanted to clarify that because it seemed like that might have been your thought, how defense, I was trying to figure out when your thought was of that, before or after you asked him that. So is that correct, that was your thought prior to asking him, and that's why you actually asked him?
Correct.
Okay, so in the video, it shows the pursuit, obviously. can't see exactly what you saw, this is the video, but if you could just tell us, because you indicated that you made some comments about tasing, and then you kind of stated your reasoning. Could you explain what's going on? What is your thought while you're pursuing a suspect that you've observed with handgun?
Yes, honestly, I'm glad you asked. Chasing somebody with a firearm in their pocket is not a comfortable situation. I could say many things. Like I said, I could state that I was shooting. I could state that,
Why would you state those things? What kind of feeling are you having?
In my mind, I want you to really, I just want you to stop. I want you to drop the gun. I want you to stop. I don't want to engage in this action because it can go either way. It can be dangerous things for both of us. So I'm advising I would tase you because one, that's less lethal. Two, it's also scary. Nobody want to be tased. So hopefully you stop running.
So your intent by warning, not just saying stop, you're giving additional warnings by things that could occur in hopes that he stops.
Yes.
Did any of these additional warnings, not just stop, but the taser, did it deter or slow the defendant down or have him stop?
I don't know if it eventually had him stop, but I know at some point he did stop running once we made it across the street. So maybe it played a factor, maybe it didn't, I'm not sure.
And defense mentioned the amount of time, 30 seconds.
Yes.
And in that amount of time, roughly, because we could only hear the end of, with the taser part, how far, I have two questions. First, how far did you get in over 30 seconds, 38 seconds?
A decent amount of space was covered in 30 seconds.
City block, a few buildings down, roughly, I know you can't tell us an exact, but.
Maybe almost a block, maybe like a little less than a block. 30 seconds is a long time in a fight, for that matter. It's just a long time. You have many chances to stop.
I understand, thank you. And during that time, again, I apologize having you maybe guess here, but do you know roughly how many times you told him to stop, whether it was just stop or stop, you're gonna get tased, anything of that nature?
I would say at least 5 to 7 times, at least.
Good questions, thank you.
No, Your Honor. Thank you, Your Honor. People move that defendant Antoine Bolden be found over on count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, obstructing, and we reserve argument. Thank you.
Your Honor, or can you step to the mic, please? Oh, I'm sorry, I keep doing this. Your Honor, defense does not believe that the prosecutor has met the burden on the second count of resisting and obstructing, especially the commands that were given over the course of less than a minute by Officer Perry's own testimony on redirect. The distance that was covered in a minor foot chase was around 1 city block, and Mr. Bolden did ultimately stop, and there was no description of given of any kind of obstruction at the point of arrest. The commands that were given were given paired with I'm about to tase you, it was not stop, or I'm about to tase you, or drop the gun, or I'm about to tase you. The taser was implied as a consequence of stopping or of actually having contact with the police in this case. That was sent to someone who was panicked enough to already be in a state of flight, means that it was a command that would be extremely difficult to follow and may not be lawful if the implication is even if you follow that command, you will be tased, sent to being tased. Additionally, the manner in which the police approached Mr. Bolden was intimidating and abnormal. They approached him in a vehicle, blocked his path on the sidewalk, and immediately jumped out of the vehicle, creating a situation where some amount of panic might be more natural than had they approached on foot conversationally. meaning that the commands which were ultimately followed within less than a minute were also delivered. They were delivered in multiple ways and difficult to immediately obey, even if they were ultimately obeyed. Additionally, the gun was not located on Mr. Bolden's person. He made no confession to having a gun. No, there was no testimony indicating that fingerprints were taken. The connection between Mr. Bolden and this firearm location, and a search from a database that was not backed up by any contact with the actual person at that point. I would ask that both counts be dismissed rather than
Thank you, Your Honor. I respectfully disagree with the defense. This is a preliminary exam, probable cause standard, not beyond reasonable doubt. The people believe probable cause has definitively been met, starting with Officer Perry positively identifying the defendant. Officer Perry positively indicating that he was certain that the defendant was carrying a weapon based on the imprint. However, he still wanted to give the defendant the benefit of the doubt because he may be a CPL holder and there's nothing wrong. He is correct with that. If somebody wants to carry a concealed weapon in the state of Michigan, as long as you have a CPL, that's okay. However, the fact that he notices this imprint allows the officer to engage with the defendant, which he did very briefly, as we saw. It was very quick. He asked him what he had in his pocket. The defendant lied and said nothing and immediately fled. Had it ended at nothing, we might not be here. But he fled. This gives officer reasonable suspicion to chase him. Now he is, and at the moment he says stop, and the defendant continues, now we have resisting, obstructing an officer. Officer is investigating what he saw, and the defendant flees on foot, causing the officer and one of his partners, and the other partner also takes off in the scout car, as we noticed on the video, that they have to now pursue him. While in pursuit, officer testifies that now it's no longer his belief based on the imprint, but that the defendant actually pulls the weapon out of his hoodie pocket and is running with the weapon in his right hand, where the officer definitively observes the weapon in the defendant's hand. At this point, obviously, there's safety concerns for everyone involved. These are situations that we see played out constantly on TV, and we don't want to see these. We do not want to see officers shot at, and we do not want to see defendants, whether guilty or not guilty, shot at. So yes, the officer is going to warn him. He's going to tase him, and officers often use the taser in resisting and obstructing while someone is fleeing, often. Luckily, that didn't have to happen here. Defendant then proceeds to falsely, obviously, assist the officer by admitting knowledge and possession of a weapon when he tells the officer where to look for the weapon that he's discarded. Obviously, he told him the wrong location, but he was well aware of the situation, and as the officer indicated, the officer yelling to him to stop while he had the weapon out, there is knowledge he had possession. The officer observed the possession. Now, there's some things that really, I don't even think it's a question of fact or trier fact, but some things that were brought up that is, I believe, irrelevant in the probable cause. Officer does not have to say, or I'm going to tase you. Stop you're about to get tased, whatever situation. The officer was very honest about his feelings in this situation. These are tense situations. He's literally observed the defendant with the weapon now in his hand while he's running. Anything could have happened, and he is correct. So for the safety of the officer and the safety of the defendant, these officers have to sometimes threaten force to get a suspect to stop, unfortunately. That is not wrong. It does not negate everything else in this probable cause. We have the defendant identified. We have the defendant observed with a handgun, not only an imprint, but actually in his hand. We observed on the video, clearly, the video corroborates everything that the officer said. Quickly asked him, the defendant flees immediately. After saying nothing, they chase him. He immediately fled. So at this point, resisting and obstructing, and the other thing that I believe is irrelevant at this point, at probable cause, they can express it to a trier fact, but I also don't know how it would pan out. But it doesn't matter, and suspects need to know this again for safety, for their own safety and for officer safety. If you engage or an officer engages with you, and you take off running and they say stop, it does not matter if it's 5 seconds or 50 seconds. You are now resisting and obstructing. You're putting everyone at danger, and you have a weapon in your possession. It does not matter that it was 38 seconds. A lot can happen in 5 feet, let alone almost a block. So I don't believe that that is a appropriate defense of everything that's occurred. The weapon was recovered, placed into evidence, and again, the officer definitively indicated that he was certain it was the same weapon because he observed the weapon in the defendant's hand. People believe probable cause has been more than that. Oh, Your Honor, and a side note, something was brought up in regards to checking. At this point, probable cause, and possibly even at the trial stage. Yes, I usually do ask people if your gun is registered, but it is not an element. It is not necessary. So even if, which it is not hearsay, but even if, let's say, that didn't come in, we could strike that comment, and probable cause would still have been met, because the registration is not necessary for probable cause or for any of the elements that, for either one of these counts. Therefore, the people ask that vote count 1 and 2, the defendant be bound over. Thank you, Your Honor.
Okay, I'm only going to address what's relevant for bind over. I am going to bind the defendant over on both charges. As Officer Perry testified, he saw an imprint, and once closer, in scout car, saw part of a gun. When he testified to, then he asked the defendant, "What's in your pocket?" The defendant responded, "Nothing." Officer Perry said that he waited for the defendant to state that he had a CPL. The reason why he waited is because CPL holders are required to inform police that they have a gun or a CPL, a gun and a CPL. Well, if they have a CPL, that they have a gun on their person. Let's stop or investigate. The defendant immediately began running, as we saw in the video. Officer Perry gives chase, sees the defendant with the gun in his right hand, once detained, or I'm sorry, not once detained, once stopped. Finally, after the chase, Officer Perry did not see a gun, but found about 10 feet from where he was detained a black handgun. The defendant, during that time, told Officer Perry where the gun was, even though it was not that location, but that a gun existed. More relevant, during the investigation, Officer Perry received or obtained the defendant's ID, and he was 20 years of age at the time. He did not have a CPL, therefore did not carry a concealed weapon in Michigan. That's for count 1. I believe Officer Perry and people have met the burden of proof, probable cause for resisting obstructing, I will agree with the prosecutor, it doesn't matter time-wise. In this case, 30 seconds running full speed is a very long time. He made several commands to stop, and he did say that he was going to take him. And I'm not going to get into police policy and all that, but that doesn't change the fact or change the elements of the crime here. He was ordered to stop. Officer Perry was in uniform, and scout card, and asked a simple question, what's in his pocket? And the defendant began running. He saw a gun in his right hand at some point, and then recovered a gun. 30 seconds is a very long time. If you ever ran a sprint, you would know that it's a very long time to run at top speed. So I do believe on both counts, you admit it's probable cause for him to have it bound over. Mr. Bolden, your arraignment on the information is going to be 2 weeks from today, April 19th at Frank Murphy Hall of Justice, 9 o'clock. All right, anything else for the record? So you're gonna keep it. Right, you're all right with it. Oh, I've got 10%. Thank you. No problem. I have a question. I want to take this one.
So I have to check now, the other one Johnson. Yeah. That's not both of yours. I understand you have to be in the reports. We're just like, we are having a lot.
Good morning. How are you doing?
Good morning, Honor.
How are you today?
It's much more pleasant in here.
Really?
It's hot out in that hallway.
Is it? We are here like, ooh, it's hot.
Oh, it's 10 degrees warmer.
March 10th.
Okay, case 2355888, people of the state of Michigan versus Namari Lenore, charged with count 1 weapons carrying concealed, count 2 stolen property, receiving and selling a motor vehicle, set for a preliminary examination. I'm also going to call the other case. We can deal with that one second. 2260079, people of the state of Michigan versus Tamarian Jeremiah Trenton Lenore, charged with count 1 stolen property, receiving and selling a motor vehicle, count 2 weapons carrying concealed, count 3 police officer assaulting, resisting, and obstructing, count 4 and 5 weapons felony firearm, set for exam as well. Appearances.
Good morning, I'm Daniela Parrish on behalf of the people, P85495.
May I please report Sarah Robinson, P6321 for both cases. Mr. Lenore, you present for the board.
And Mr. Lenore, can you state your full name, please? Okay, and Ms. Parrish, you want us to start with the 23 case?
Yes, Your Honor.
Okay.
Please. Thank you. The people at this time move for an adjournment. My apologies, Your Honor. I spoke to the OIC who just came back from furlough and cannot confirm whether one of our necessary witnesses who is not here actually received the subpoenas because that OIC was on furlough. And the way our new subpoena system works, unfortunately, it's requiring OICs and 50% of the time to actually forward these subpoenas off to the offices. So due to the fact that Officer Glover, who is the officer in charge, just got back from furlough, he cannot confirm if that necessary witness ever actually received a subpoena. Therefore, just for judicial efficiency, we can obviously reissue it, but I would appreciate due to there being a valid reason here, and that's not actually knowing if these officers, the one in particular had notice, we would ask for a brief adjournment of just at least 7 days so that we can get these subpoenas out.
Anything from the bench?
Judge, I would object. This case was set more than a week ago. If OIC Quentin Glover is the OIC, I believe, is that correct? And he's commercial auto theft. All of the auto theft, you know what, strike that. I do object, Your Honor. This date was not set in the usual calendar 1 week after the probable cause conference. There was a gap in time in this case, actually going back more than 2 weeks.
March 17th.
All right, so my math being what it is 2.5 weeks ago. So I do believe that would go beyond the OIC's furlough. I don't know if it's per private schedule, but either way, there are other people that work in the commercial auto theft unit that could have gotten subpoenas out to the necessary witness officer. I'm going to object as the matter is dismissed.
Your Honor, if I may, I do not know the exact date, and since the OIC is not, he just walked in, so we could ask him to find out. Our subpoenas do not go out on the day, it goes out on the next business day because of court. Again, and my apologies, we have a new subpoena system. So I cannot actually say, and neither can defense indicate whether anyone else could have access. The way our new PBK system is, if an OIC is subpoenaed, he is given all the subpoenas, and unfortunately, he has to manually go onto the system, download them, and forward them. So we don't have, it's unlike the old system where we can go in and check via email, because we used to do it via email with the court officer here at 36. We cannot do that anymore. So I would like the opportunity to put the OIC on the record. He could indicate, but the subpoenas would have went out no sooner than the 21st, at least 2 business days afterwards, because we do have to wait for the court to send it over to PBK, which happens midnight of the next business day.
Okay, I'm going to dismiss without question. It's the people's responsibility and officer's responsibility to bring their witnesses to court. This was set March 17th, so the officer was not able to handle their case, it should have been passed on to someone else, or someone should have been responsible. It was more than enough time to let someone know to be here today without any indication as to why the officers aren't here, other than they weren't subpoenaed, is not enough for good cause. I'm gonna dismiss without prejudice, it needs to be reissued. If need be. I'm sorry. And Attorney Miller, for the left 30, I know you have to head back across the street. Off the record, on Mr. Benori, this is case 2260269, he was State of Michigan versus Dana Washington, who was charged with one count of weapons, dangerous weapons, using self-defense spray device, set for an examination, state appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Jay Grant Miller, 258658 on behalf of Mr. Washington.
And is it correct, Attorney Miller should have not been in contact with Mr. Washington?
Your Honor, the number I was provided with Mr. Washington was not good. The other number I found also did not receive any kind of response via text or phone call. This matter mistakenly was put on my schedule for today. It was originally scheduled for Monday. The court was gracious enough to put it over till today, and I don't believe he showed up on either occasion.
He did not.
I understand what people are going to ask for, Your Honor.
Yes, would you like to put that on the record?
Yes, Your Honor, people move for cases.
Okay, it will be a case, $2,000 cash. We'll start over. The administration is found.
And Your Honor, in the event he reaches out to me, I just ask for his permission to walk him in and hopefully potentially get a personal bond if he can make contact. I don't know if it's a phone problem or what it is.
Okay.
Thank you, Your Honor. Have a great day.
Good call.
I hope you're not down here tomorrow.
I'm not, court's closed.
I,
It's a holiday for us.
a couple of the courts across the street are still open, but I have refused.
That's a good one.
Thank you, Your Honor. You do.
Okay, back on Mr. Benori. We still have case 2260079. Those appearances have been put on already. What is, I should say, are the people ready to proceed on this case?
Yes, Your Honor. I'm sorry, one more.
Sorry, 1 second. What you have to see, sir?
I'll ask a question after.
So docs?
It's Attorney Doc.
Docs is the one we're waiting on, yes?
Sorry.
I just want, I didn't know if you knew if witnesses were out there.
No, I read it wrong. Cross Nelson?
That's who's here? Okay, we're on the record as the people of the state of Michigan versus Justin Darnell Mallory, case 2260476. Mr. Mallory is charged with count 1 and 2, assault with intent to murder. Count 3 and 4, assault with intent to do great bodily harm less than murder or by strangulation with a habitual offender court offense notice set for examination today. Appearances.
Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
Good morning, Your Honor. Wyatt here is P54891 on behalf of Justin Mallory, who stands to my right.
Mr. Mallory, can you state your full name, please, for the record?
Justin Darnell Mallory.
Good morning. Okay, today's the day set for examination. I have a waiver form. Is this going to be a waiver?
Yes.
Yes, Your Honor, and the people do not object as we just take a moment to speak with the complaining witness on the case and they're okay with it.
Okay,
Thank you.
okay, Mr. Mallory, I'm going to ask you a series of questions. If you don't understand my questions or if you can't hear me, let me know, okay? You understand that you have a right to an exam?
Yes.
And that if you were to demand an exam today, the prosecutor would have to show at the probable cause standard, which is a much lower standard, but still a standard in criminal law, they would have to show today that those charges I read off in the complaint were committed in the city of Detroit and that you probably committed those crimes. You understand that?
Yes.
And that by waiving your exam today, that means the people do not have to show any evidence regarding those charges today. You understand that?
Yeah.
That's not, you also understand you're not giving up. All right. Did anyone force you or threaten you to waive your exam today? Did anyone promise you anything for you to waive your exam? Okay. I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Frank Murphy Hall of Justice, Third Circuit Court, 1 week from today because you are in custody, so it'll be April 12th at 9 o'clock a.m. All right, anything else? Need a party?
Nothing further.
I have everyone's signature, so we are all set on Mr. Mallory.
Thank you.
Thank you.
I'll see you next week.
Okay, so I just spoke to, or not spoke to, but I've been emailing back from Lamont Grady. She Tuesday because it's a PCC. It's gonna be adjourned Tuesday because she wants her client here and he was not brought or printed out for Zoom. So just for your records.
And when I walked in on Tuesday, you can tell me, I told you already.
It's a PCC.
Yeah, so then we're good, because by Tuesday, it'll already be up on your docket.
Yeah.
Like,
I
right
just
here,
want
my
you,
days.
you probably crossed them off.
All right.
So back to Mr. Broussard.
Let me just.
You call free too, right? You have some. Okay, we're back on the record on the people of the state of Michigan versus Mari Maya Nori. Appearances have been put on the record already. This is for case 2260079. And I believe this will be a hold, is that correct?
Correct.
Any preliminary matters?
There is one preliminary matter, Your Honor. I just showed defense counsel lab report that I'm making a copy for her just because my computer is moving slow, so I cannot. I took it out of the discovery packet myself, so but again, I made a copy because defense may not have had it, I do not know. It is a preliminary matter per se admissible. The 766.1118, NSP laboratory report in which they obtained DNA from the complaining witness on the case, the owner of the vehicle, and also DNA from the defendant. The laboratory report indicates, I apologize. The results were based on the DNA typing results obtained from the firearm swabs. It is approximately 14 octillion times more likely it originated from Timerian flounery and one unrelated unknown contributor. This is from DNA that was taken from a weapon that was recovered in this case, and the laboratory report indicates a positive result in DNA being found, defendant's DNA being found on the weapon. As I stated, a copy has been given to defense.
Judge, I would object. A copy was given to me a couple minutes ago, 11:47 a.m. minus 2 minutes, 11:45 a.m. This was not included in my discovery package. I have the email here from the prosecutor. It wasn't included. And I'm going to object. It should have been, if it was going to be admitted, it should have been given to me in advance. I know that today is a preliminary examination, and I have issues with the search warrant. I have issues with the affidavit that the trooper gave to the magistrate to get the search warrant to take my client's DNA. I know I can't raise that.
I'm sorry, can you please just step to the.
Yes, I have issues with the search warrant. I have issues with the affidavit where the trooper indicates that he believes he has police. When you're producing, making an affidavit, you're supposed to state the firm knowledge, not what you believe. On some vague description, 5'9", black male, 180 pounds. That was the basis for the search warrant from some other incident. And I know today is not the day to challenge that search warrant, but I just received this today, and I am going to object to this going into evidence today.
Your Honor, may I respond? Yes. As with many of our MSP lab reports, prosecution often receives them on the day of preliminary exam. The notice that defense would have had is actually in the discovery packet, where, as she indicated, we're not going to argue today the search warrant, but there was a search warrant that indicates that the swab was taken from the defendant to do a lab report. And these lab results come in most of the time on the same day. That is why we show defense before we start the preliminary exam, because a lot of times we ourselves just given the same day. But it is per se admissible, again, just for preliminary cause purposes, to be admitted under 766.1118.
And Judge, this is my final word, is that I was not put on notice. I was put on notice that DNA was taken. I was not put on notice that this gun was going to be tested. So no, there is no notice. What I should have known or would have figured out is this. And I should have received this before today.
So what is it that you need as far as, now that you have it, what you need to be?
I have issues
with the whole search warrant. I have issues with the affidavit written by, excuse me, Trooper Lambusi. I think it's misleading.
But as far as the report that was provided,
My objection is that I should have received this report today.
okay, well, I'm saying now that you have it, is there something that you need time to prepare for to move forward with the exam?
If the court wants to grant a short adjournment, yeah, I would like to look it over. This is a one witness exam. Is that correct?
Your Honor, I understand, and when you say a short adjournment,
Are you talking today?
I'm thinking 5 minutes because we've been waiting for a few hours already to do this case, and our witness has been here. And I understand that she wants to review it, but again, even if she objects to it, it's per se admissible. So it's not like there needs to be a lot of review that goes into this. It states what I already stated in the preliminary exam. She conflicted her objection on
I'm not
record.
going to tell her how to try her case
No, no.
well, but that's why I'm asking her how much time she needs so that we can move forward. And otherwise, we can get into whether or not it's actually safe. I don't want to get into that because you all are both saying different things. But if it can be resolved today with looking at it, talking to your client, that would be ideal. We're at 9:30 ready to go. But if there's something that you have to review, that's going to take more than enough time today to look at, then please know that.
I would like to take more time, and I don't think 5 minutes, and it may not be an issue, but I'd like to take the time to look at it. But if the court is not, if the time frame is not allowed, then I'll proceed with my objection on the record.
It's just it's a report of the fingerprinting.
That was DNA that was taken from my clients inside of his cheek lining.
It's the results of that DNA test in relation to the weapon that was also recovered. And Your Honor,
Attorney Ronnie, is there any way you can hold this today?
yeah, I prefer to hold it today.
Just share it.
Yeah, I can hold it today, just my objections on the record, Judge.
Okay. Do you want to speak to your client before you begin?
No, you want to proceed.
Any other preliminary matters?
Just the lab report, Your Honor. Thank you.
It will be 766.11, you said B?
A, Your Honor, just double check. A.
Seven six six point one A.
Yes, Your Honor. Am I saying the wrong one? Lab reports?
I'm only seeing for like that 766.11.
Yes. 1, and then 11. Let's say your way. I'm sorry if I'm right. 766.11, 1A.
That's the testimony of a witness.
Okay. For the first day admissible, let me just double check it. It's a MCL 766.111A. I will double check it because I'm having one of those days, so I will not pretend that my numbers do not get messed up right now. Thank you very much.
Take your time.
And Your Honor, it's It's the same statute that comes into play when we put in drug, lab results.
11B.
You say B, Your Honor? I might have written it down wrong.
And it would be 11B.
And I'm double checking it.
Here, I'm.
And I apologize, my computer is running obscenely slow, so I can't look. Unfortunately, anything up right now. is 2 hours. That being said, Your Honor, I hate to say this and come out overly confident, but the people believe that they have probable cause even without this, but our office likes to put these labs on the record. This lab was a bit overkill.
Is that what you're looking for?
Yeah, did you have A, 11A? Oh.
I'll print it out, okay?
We actually. Thank you. My apologies. Again, if there is an issue that would cause delay, and I hate to be overly confident, but based on probable cause standards, people could proceed even without.
So do you want to admit it under?
I would like to admit it.
6.11B?
Yes, you are. Okay, and thank you. My apologies for the confusion.
Attorney Robinson, do you want to do that? It would be under 1C, a report other than a law enforcement report. That is made or kept in ordinary course of business. Y'all just on that for the record. Okay. All right, anything else on there?
Nothing from the people, Your Honor.
All right, call your first witness.
Thank you, Your Honor. The people call Cody Lungoski.
And I just want to notify everyone since you all are in here. We just received an email about a tornado warning. Okay, back on the record on Mr. Mallory. Did you already get?
Yes, ma'am.
I'll swear you in. Swear to tell the truth, and nothing but nothing.
Yes, ma'am.
All right, and you can hold the mic in your lap. It's up to everyone else. I'm okay with it. For recording, okay?
I'm
You
sorry,
okay with him pulling his pants down?
that would be great. No, that would be wonderful, very good, easier for me. Thank
Could you restate your name for the record?
Cody Longoski,
Could you please tell the court where you're currently employed and in what capacity?
I'm a trooper with the Michigan State Police.
How long have you been in that trooper?
Approximately 5.5 years.
Were you employed in this capacity on October 10th, 2022?
Yes, ma'am.
Were you by yourself or with a partner on that day, sir?
I was with a partner.
You recall your partner's name on that day?
It was a trooper Renee Mejia. Yes, first name Renee, R-E-N-E, last name Mejia, M-E-J-I-A.
Were you in a full or modified uniform on that day, sir?
I was in a full uniform.
And were you in a scout car?
Yes, ma'am.
Fully or semi-marked scout car?
Fully marked.
Since you were with a partner, could you tell us, were you the driver or passenger in the scout car that day?
I was a driver.
Did your duties as a Michigan State trooper take you at or near Greenfield Road near West Chicago in the city of Detroit, County of Wayne?
Yes, ma'am.
Can you tell us why you were in that area?
I was running just general traffic that day.
So you were on that, fair to say, patrol?
Yes, ma'am.
While at or near said location, did you observe something that drew your attention, sir?
Yes, ma'am, I did.
What was that?
I observed a vehicle coming towards me at a high rate of speed. And using my opposite radar, I was able to clock that vehicle at 57 miles an hour in a posted 35-mile-an-hour zone.
Do you recall what type of vehicle that was?
It was a silver Chrysler 200.
After confirming with your radar that vehicle was going well over the 35-mile-per-hour speed limit, what, if anything, did you do, sir?
I flipped around and then my partner ran the license plate fixed to the rear of the car and leaned.
While investigating the license plate, what, if anything, did you do?
A lean query popped up saying the vehicle was stolen in a car.
I'm gonna object to your saying his partner when you leave. To clarify, sir, you indicated that it popped up. Did you observe the results of the lien search?
Eventually, but I was told after he ran it.
And again, that's your saying, Judge. Your Honor, I'm going to indicate that it is effect on the listener. At this time, we are not trying to, we'll get to that. But at this time, we're trying to show effect on the listener. Obviously, he's already about to initiate a traffic stop as he's stated. But again, I'd like to have it down as an effect on the listener. As of right now, it's fine to not go in as truth of the matter asserted.
But the charge is for stolen 200.
And we'll get to that point, so however you rule is fine.
So it'll be sustained at this point. For hearsay.
Officer, while your partner was investigating, what, if anything, did you do?
I continued to follow the vehicle until the vehicle turned into a driveway.
Did you at any time initiate a traffic stop, or you're just following him? What happened?
This is leading objection.
Okay, I will rephrase. I apologize. Why were you following him?
I was following until another unit could make my location if he kept driving.
And what happened next, sir?
Once he pulled into the driveway, I turned my lights on, my emergency lights, to conduct a traffic stop.
Once you initiated your lights,
conducted the traffic stop. Could you please tell us what, if anything, you observed?
I observed the driver step out of the vehicle and start walking towards the residence that would have been towards his southwest of where he was at.
When he started walking away from the initiated traffic stop, what, if anything, did you do?
Once he started walking away, I ran around the vehicle to try and cut him off from going into the residence. At which point he then turned and started running past my full motor patrol car.
Did you indicate anything to him when you cut his cap off as you indicated?
I told him to stop.
Did he comply?
He did not.
And you indicated that he began to run
Yes, in a full sprint.
from you or away from you? Or towards you or away from you?
Away from me.
What, if anything, did you do once? Well, let me actually stop there. Would you be able to identify this or recognize this person, this driver, if you saw them again today?
I would.
Is that person in the courtroom today?
I believe so, but he didn't stand up there. I'm kind of blocked behind you guys.
Madam, may I ask the mask to be also lowered? The mask lowered. No one has to stand. Everyone can just lower their mask.
Sir, is the person, the driver that you observed that day that fled from you, are they in the courtroom today?
Yes, ma'am, they are.
Could you please indicate for the court record where they are located in the article of clothing?
They're sitting behind the defense attorney wearing a green jumpsuit with blue mask.
Your Honor, may the record reflect the identification of Marion Lonery?
No request.
Officer, what, if anything, did you do once the defendant started running from you?
I ran after him.
Commands?
Yeah.
Any additional, I should say, commands?
Yes, I told him to stop.
That's suggesting.
I will rephrase.
I just want to get the objection on the record, because I didn't hear it.
Oh, okay.
I'm sorry, leading, the question was, did you give additional commands? And that just suggests the officer an answer.
It's leading.
And I apologize. I will rephrase. Did you say anything to the defendant at any time once he started running?
Judge, I think this was leading too. I mean, what did he do next? Not what did he say or.
It is leading. By law, yes. What if the law would happen next over and over and over? That's how we do it.
Judge, yes, Judge.
Please disregard the question. Please tell us what you did after the defendant started running.
He began running east from our location. I gave a verbal command to stop.
Did he comply with your command, sir?
He did not.
What did you do next?
Continued running. We ran across the street we were on, and on the south sidewalk, I continued to run where I observed him then grab a black firearm with an extended magazine from his waistband.
Once you observed the defendant in possession of a firearm, what, if anything?
And that's a leading question.
He literally just said that.
He had, but to phrase it, he was in possession of a firearm.
I can say exactly what he said, but I thought that
Testimony
this
said
is
he grabbed it from
His waistband.
his waistband.
it seems, okay,
That would be the
I thought it was worse for me to say all of it, but that's fine. Once,
I will overrule that objection.
okay, thank you.
Can you say the question
What
again?
did you do after your observation of the defendant?
Once I saw him grab the firearm, I yelled, "Drop it" twice, at which he then dropped it and it hit the sidewalk and I observed where it landed.
Could you, and I know you said something about a magazine, could you describe the weapon that you saw the defendant dropped to the ground?
Yes, it was a black handgun with an extended magazine.
And did you clearly see where it fell?
Yes, ma'am, I did.
What did you do after the defendant dropped this firearm?
I just took a mental note and just kept chasing after the suspect.
Did you eventually?
You said you did what?
Just took a mental note of where it was at.
Thank you.
Did you eventually catch up to the defendant, sir?
I did.
Did you detain the defendant?
Yes, I did.
What did you do after you detained the defendant, sir?
After we detained them, we walked the
And I'm
side.
just gonna stop you before defense may. Can you please tell us who we is?
Sorry, Trooper Mahia and myself walked the defendant back to our car, walking along the south sidewalk where I observed him drop the firearm.
Was the firearm still there when you walked by?
Yes, ma'am, it was still on the sidewalk.
Okay, and what did you do?
At that point, I put gloves on and secured the firearm.
Do you recall if that firearm was loaded?
Yes, ma'am, with one in the chamber.
Do you happen to recall the type of weapon it was that you, that weapon was after you recovered it?
It was a 6 hour, but I do not know the exact model.
Insurance, looking for the actual troopers. And I'm sorry, if you don't mind repeating, what kind did you initially say? I didn't hear the title that you gave that.
The 6 hour.
The six what?
SIG, SIG, 6 hour.
Could you tell us how it is that you're certain that that weapon, the 6 hour, is the same, would be the same one that you saw drop from the defendant's person?
Yes, well, I observed it fall at the first corner house at the intersection where we made our traffic stop right on the sidewalk, as well as the distinction that it had the extended magazine and it was all black.
So this 6 hour had the extended magazine?
Yes, ma'am.
In the course of your investigation, sir, did you discover whether the defendant had, what the defendant's CPL status is?
He did not have a CPL, and being as 18, he is not eligible for a CPL.
In the course of your investigation, did you have an opportunity to learn if the weapon you recovered was registered?
It was.
Was it registered? Who, if anyone, was it registered?
I don't recall the name, but I remember them being deceased.
The deceased person?
Yes.
Did you place this weapon into evidence after recovering it, sir?
Yes, ma'am, I did.
What did you do after recovering the weapon on that day?
Can you rephrase that question?
After you recovered the weapon, could you tell us what you did? What happened next?
After we recovered the weapon, it got sent to the lab for, check that. After that, I got with an evidence technician to swab the firearm for DNA. And then it got sent to the lab for processing.
And did you obtain any results from that DNA swab?
We did.
Your Honor, I'd like to just place in the record the preliminary matter that was brought in regards to the DNA results from the MSP lab.
I'm sorry, on the what?
On the weapon that you just indicated that they sent DNA results.
Under 756.11B1C.
Yes, thank you, Your Honor.
And with Attorney Robinson's objection.
So if, and thank you for that. Going back, sir, to that day, what did, and I apologize and I'll try to rephrase it. What, if anything, did you do while still on the scene?
I searched this person.
Okay. Did you recover anything from the defendant's person?
Yes, I recovered the car keys for the vehicle we stopped.
The keys to the Chrysler 200 that defendant was driving?
Yes, ma'am.
Did you indicated that, how are you certain that the key that you recovered from the defendant went to the Chrysler 200?
The key fob was able to lock it.
So you attempted, so
Yes.
did you personally?
Yes.
Okay. As far as that vehicle, did you do anything else with that vehicle aside from testing the key fob?
I did not. Just, well, we towed the vehicle. That was it.
In the course of your investigation in regards to the actual vehicle, did you investigate the status of the vehicle? You yourself personally?
I did.
Okay. And can you tell us what your investigation indicated, sir?
Yes, I eventually I looked at the lien return for the vehicle, and I physically observed the lien query that states the vehicle was stolen, and in conjunction with the carjacking.
After getting this information yourself from lien, did that information indicate? You said it's in conjunction with the carjacking. Did it indicate who made this report?
The Detroit Police Department.
Okay. Did it indicate who the person was that reported that owns the vehicle?
Yes, I don't remember the first name, but the last name was Maxwell.
And I'm gonna object, Judge, and I have a few questions, so this is actually hearsay. I'm asking what's in this Detroit Police Department. I'm sorry, this is hearsay to what the contents of that Detroit Police Department report is. The witness is a Michigan State Trooper. That was not his investigation. So that's hearsay, Judge.
I can
Is it
rephrase.
relevant?
I can rephrase the question. I'd like to bring in the ownership hearsay exception, so I can rephrase the question. You know, he's already indicated that he saw that it was reported stolen. I can rephrase the question and move on from the actual report. Did you make contact with the registered owner of the vehicle?
I did.
Do you recall the name of the individual that you made contact with as the owner?
I can't remember the first name, but the last name was Maxwell.
If I were to show you your report in making contact, would that refresh your memory?
Yes, ma'am, it would.
Yeah, I approach your honor. Yeah. Trooper, take a look at that. We don't want you to read from it, but once you've read that completely and your memory's been fully refreshed, I will continue with the question. Just let us know when your memory's been refreshed.
It's been refreshed.
What's the name of the owner of the vehicle?
DeAndre Maxwell.
And what of vehicle does DeAndre Maxwell own?
A silver Chrysler 200.
This is the same vehicle that is involved in this incident that you just gave testimony about?
Yes, ma'am.
Did the owner indicate whether they gave anyone permission to drive that vehicle?
He did not give any permission.
Did you happen to ask the owner the condition of their vehicle?
In regards to evaluating,
And what was the value that they indicated on their vehicle?
I just read from the list, so, and he said it was in the $1,000 to $20,000 range.
Thank you. Further questions?
You indicated that my client is speeding, he's traveling the opposite direction. How are you able to detect the speed?
I have opposite radar, which detects the vehicles coming towards me.
And then what time, at what point was you able to read his speed?
When he was coming towards me.
Coming towards you?
Yes.
All right. And it flipped around, those were your words?
Yes, ma'am, I did U-turn.
Yeah. And how far down was he after you effectuated your U-turn?
When I made the U-turn, I observed him then turning east on, I don't recall the street that he started turning east onto.
Do you know what street you were on?
Westfield, I believe the name.
And was this to be picked up on your dash cam video?
Of me turning around?
Yeah, the beginning, the initial interaction with my client.
I believe so. It, my video goes 30 seconds prior to light activation. I'm not sure if it was counted.
And how many blocks did you follow him before the stop?
He crossed one intersection and then turned right and then immediately right into a house. I'm not sure how many blocks you would say that is.
And while you were behind him, your dash camera was working before you turned on your overhead lights, is that right? You picked up some of this?
Yes, ma'am.
So your dash cam does work and record without turning on the overhead lights, right?
Yes, ma'am. It records 30 seconds prior to turning on my lights.
All right. And you were able to follow him in the car, and the car was obeying all traffic laws, using turn signals, stopping at stop signs.
Yes, ma'am.
All right. And you indicated you effectuated a traffic stop, but actually the car had already stopped and parked before you turned on your overhead lights. Isn't that right?
It did pull into a driveway, yes.
So you really didn't stop the car was already parked.
Yeah, I did stop the car, yes.
Pardon me?
I did create it to make a traffic stop, yes.
You turned on your lights after the car was already parked, correct?
Yes,
In a private residential driveway.
in a driveway, yes.
All right. And I just want to ask you, what is the procedure, the Michigan State Police procedure for approaching the car during the traffic stop? What is the policy? How do you approach?
We don't have one
You don't have a policy?
on how to do a traffic stop, on how to make an approach, no.
No?
There's
Okay.
different options based on safety and officer preference.
Preference?
Yes,
Okay. So in the academy, they told you can just do whatever you want.
we can make a driver's side or passenger side approach. I'm not sure what your
Okay.
question is regarding.
All right. In this case, you didn't do a driver's side approach or a passenger side approach, did you?
No, because they ran from the car upon my lights.
All right. So when you first encountered my client, you were actually from another house as he was walking. You didn't approach the car. You went a different direction, right?
I went around the vehicle, towards his direction, yes.
When you got out of your car, you walked away from my client, the vehicle that my client was in.
I walked in the direction your client was going.
You weren't out of the car first?
I have to be out of the car to walk.
I'm just asking you. Were you out of the car first? Before my client?
No,
No, he got out first?
yes,
And you were wearing body worn camera?
yes, ma'am,
All right. And your first interaction with my client, you were actually both on foot, face to face?
yes,
All right, and then you indicated he turned around
yes, ma'am,
and ran. Okay,
Yes,
and
ma'am.
all of that would have been on body worn camera?
yes, ma'am,
All right, and this was nighttime?
yes, ma'am.
And how far behind were you at him initially?
Initially 1 to 3 feet,
1 to 3 feet, and then it increased, right?
yes,
All right, so he was a bit faster than you initially, right?
initially,
All right, and how far behind him were you when you indicated you saw a weapon?
maybe 10 to 15 feet,
All right, and while you were running, did you have a light on your body of any
I
kind?
had a flashlight on his person,
Okay, in your hand?
yeah, in my hand illuminating him as well as the firearm.
All right, and did he turn around anytime during this pursuit, or was he running away from you?
He was running away, I don't recall if he ever turned and looked back.
Okay, and you have vision of, you could see his back?
I could,
All right, and you were able to see his waistband from the back?
yes, ma'am,
Okay, and I want to ask you about the hearsay form that you filled out.
Okay.
And you did already review it, the prosecutor presented to you, did you refresh your memory already?
I did,
All right, and you signed it phone interview.
correct.
Can you explain why you signed a phone interview and not your name?
Because the signature is for the client, not myself.
There's no place for you to sign. The way I read this form, it says that I am a police officer. You're familiar with this form, right?
Yes, ma'am.
And this is a state of Michigan hearsay form?
It's a Wayne County, PSMD form.
All right, so it's a boilerplate form used over and over again?
Yes,
All right, and it says, at the beginning sentence, it says, I'm a police officer employed by the Michigan State Police Department. I've spoken with the witnesses involved in this case. I'm not gonna read the whole form. Then it has a space for the witness that you are, put his name in. So this is akin to an affidavit, is it not?
I'm not sure what that means.
You're the one, this is your statement. Would it be appropriate for you to sign this form?
No,
No?
they're supposed to sign it, but due to the late night, phone interview was conducted.
All right, we did this on October 2022.
Yes, ma'am.
You spoke directly to Mr. DeAndre Maxwell.
Yes, ma'am.
All right, at any time, did you interrogate my client regarding this case?
No, ma'am.
Was he interviewed by your partner, to your knowledge?
To my knowledge, no.
And you conveyed him where after you arrested him?
To the Detroit Detention Center?
And once he was taken in there, you know, any officer there, Detroit Police Department or any other Michigan State trooper interviewed him?
As regards to the state police, we did not interview them.
And it's just to the Detroit Police Department?
I cannot say what they did.
You have no knowledge? Did you enter the DDC?
I did not.
You dropped him off at the outside horseshoe, as they call it?
Yes, and then my partner walked in while I stayed in quarantine.
Regarding the search warrant, did you ever indicate to the magistrate that it was your intention to test the gun? Any question?
I don't recall.
You don't recall? All right, I don't have any other questions. Oh, no, you're on. Mary, ready?
Thank you, Your Honor. People move that defendant Marion Lowry, I apologize for my pronunciation, be bound over on count one, stolen property receiving a stolen motor vehicle, count two, weapons carrying concealed, count three, police officer suddenly resisting obstructing, count four, weapons stolen firearm in relation to the receiving a concealed motor vehicle, and count five, weapons stolen firearm and in relation to resisting and obstructing a police officer. I would just like to note that it should, the counts indicate a sixth count. That's just an advisory, a motor vehicle advisory that's not technically, we don't have to be advisory on there, so it should not. Why it says count six, but it should just be an advisory. And the people reserve argument. Thank you, Your Honor.
Judge, I would object to the bind over, even by probable cause standard, there is no proof that has been put in that my client knew or had reason to know that this car was stolen. Simply being in a car, driving a car, does not mean that the person has knowledge or reason to believe that there's knowledge. Being in possession of keys is also not indicative of that. So I would ask the court to dismiss that count. As to the carrying of the concealed weapon, I would argue that my client never concealed the weapon, that he had the handgun, it was never on his person. If indeed he had it at all, it was never concealed. So I would ask for that count to be dismissed. As to the assault resist obstruct, there was no testimony that my client assaulted, endangered, battered, wounded the state trooper. I would argue that my client was already parked, lawfully parked in a residential driveway. Their encounter was actually face to face in front of a private residence. And my client was startled, I would argue, and moved away from the officer. I don't think that rises to assault, resist, obstruct. And as far as this officer, he really did not have, there's no testimony that he knew at that juncture that this was a stolen car. Initially, he indicated that he didn't have the information that he found out later. So there was really not a basis for him to detain my client at that point. His testimony was that my client was speeding. So at that point, at best, it would be to issue a civil infraction. I would also ask that the felony firearm be dismissed as well, based on that they have not made proofs by probable cause standard for receiving and selling motor vehicle.
Thank you, Your Honor. Starting with count one. Well, before I even start with counts, the trooper indicated that he observed and clocked the vehicle the defendant was driving, that the trooper observed him exit out of this vehicle as the driver of a Chrysler 200 that was speeding over 20 miles over the legal limit. At that point, he has broken the law. He has reason to pull over. And just with the trooper following behind him and turning on the lights, even if he pulls in a driveway, a lot of times people pull in driveways while, you know, or pull into safe areas that are well lit when officers initiate a traffic stop.
I'm gonna object, that's not in evidence. He put his light on after my client was already stopped in the driveway.
He was stopped in the driveway, yes, but he also testified that he followed behind him and he turned on the lights. So you have a vehicle, a police officer, a fully marked scout car behind the the vehicle the defendant is driving, behind him, and the lights initiated. He disregards the lights being initiated and proceeds to exit his vehicle because the trooper indicated that he initiated lights, granted, even if he stopped the vehicle in the driveway, he initiated the lights prior to the defendant getting out of the vehicle, because he testified he initiated the lights and the defendant then exited the vehicle and started to proceed toward a residential home. Now, the lights are on and he's disregarding the lights and he's moving towards the home. The trooper testified that he then immediately exited his vehicle to cut off the defendant. Because remember, we still need to issue the ticket as you have indicated. And in order to do that, you have to make contact with the guy that is
just
speeding.
conjecture as to what the officer was gonna do with regards to a speeding ticket.
Well, you have indicated that he had no reason. At this point, he was speeding. He has a reason to make contact with them. So because the defendant is proceeding towards a resident, as the trooper indicated, he went to cut him off and has been stated several times, including in your closing, is that they were face to face. Face to face, so defendant has a police officer right in front of him. Lights are on in the scout car. And his reaction is to turn around and flee on foot. At that point, he has done count 3, just at that point, because as you fail to indicate, that he does not have to assault, does not have to batter, does not have to wound. He simply has to either resist, obstruct, or oppose an officer. And an officer is in front of you, officer indicates stop, and he turns around and runs. This is, at that point, probable cause has been met with count 3. Now, he proceeds to flee from the officer. The officer is pursuing him now. And to go back to count 2, now the officer testifies that he himself with his own eyes observes the defendant pull a weapon from his waistband. He did not testify that the weapon that he was open carrying or from his waistband. Logically speaking, a weapon in your waistband under the statute a weapon does not have to be fully concealed. Even partially concealed is enough to be carrying a concealed weapon, which requires a CPL, and at his age, he did not legally have a CPL. So at this point, the moment the officer observes him with that weapon, he is met with probable cause for count 2. But it goes further, and the weapon is actually recovered. As the trooper indicated, he observed where it dropped, extended magazine. He went back, picked up that same weapon with the extended magazine in the exact place that the defendant dropped it. So we believe probable cause has been met for count 2. As far as count 1, having possession of a stolen motor vehicle, knowing or, it's important, having reason to believe the motor vehicle was stolen. The fact that the defendant fled from the officer at that time can give probable cause. Now, this is for preliminary exam purposes. From a probable cause standard, this driver was in possession, was observed in possession. When he got out of the vehicle, he immediately fled from the officer. So it is, by probable cause standard, we can reason that this defendant may have had reason to believe that the vehicle that he was in possession, that he had the key fob or key to, was a stolen motor vehicle. Therefore, for probable cause purposes, and then obviously the trooper actually made contact with the owner of the vehicle. The hearsay exception for ownership is, I believe, I hope I don't mess this one up, 1101B8. And it doesn't necessarily have to be in the written form. So whether the trooper signed it or put over the phone, the fact that the trooper testified under oath allows the hearsay exception to come in to play, and the owner of the vehicle did not give anyone, let alone the defendant, permission to have possession of the Chrysler 200. Count 4, people believe that count 1, count 2, and count 3, by probable cause standards, the probable cause standard has been met by the testimony of Trooper Wadowski, and therefore count 4, weapons, felony, firearm, would go along with the receiving, selling, stolen motor vehicle, and count 5, weapons, felony, firearm, would go along with the resisting and obstructing of a police officer. Thank you.
For her testimony from Trooper Wadowski, without going through the facts once again, you all heard them. I'm just going to run down the count. Well, I do believe people have been burden of proof, which is the probable cause standard on all counts. For count 1, stolen property, receiving, selling a motor vehicle, that would be a question of fact. For the trier of fact, there was testimony that the trooper on his own knowledge did search and lean, and the car was stolen in conjunction with carjacking. Count 2, weapons carrying concealed. The trooper testified that he saw the defendant have a waistband with an extended magazine out of his pants or the back of his pants. Also, the defendant got out of the car and began to run. So CCW or carrying concealed also would apply to him being inside the vehicle at the time that he was in possession of the gun that he did not have a CPO for, as he was under the age of 21 and could not even be eligible to have a CPO. Count 3, which would be for a police officer assaulting, resisting, and obstructing. Mr. Bernori, based off the testimony from Trooper Wadowski, did resist, obstruct, and or oppose. Once he began running and gave chase after the trooper initiated a traffic stop that was the initial traffic stop based off of speeding from his reverse or opposite radar, as he described. And the 2 companions or the felony firearms attached, 1 for receiving and concealing a stolen motor vehicle, as well as the resisting and obstructing a police officer. Those will be bound over, as well as they're attached to 2 counts that people have met probable cause. Mr. Bernori, since you are in custody, your AOI, your arraignment information will be 1 week from today. So it'll be April 12th at 9 o'clock a.m. at Frank Murphy Hall of Justice. Okay?
Judge, may I address mine?
Yes.
My client is 18 years old with no My client is 18 years old with no prior criminal record. If he were released on tether, he could live with his father who lives on Tuxedo. My understanding that he has 3 small children, and he will seek gainful employment if released. He has strong ties to the community, born and raised here in Detroit, Michigan. I'm asking the court to consider reducing his bond.
Anything from the people?
Your Honor, the people vehemently object, regardless of what his current status is, which obviously does not include any HIDA. He does have this case that took place on October 10th. And then again, allegedly, but we had a case today dismissed that's going to be reissued with similar charges, but a few months later. Obviously, this is not on his record yet. I completely understand that, but having this knowledge, knowing that a case was just dismissed with him, similar, just a few months after this, similar circumstances, similar charges. And this is a resisting and obstructing case as well. The people vehemently object to any reduction in the bond in this matter. He may be young, but he's already on the wrong path, and I don't think we need to assist him any further by reducing his bond.
Okay, so Attorney Robinson, 10,000, 10%, is that correct for his bond, John? Okay, as of now,
Yes. Your Honor, and I would just like to also indicate that there is also, related to this case, potential additional charges that may be later added. As Trooper testified, this all started with a potential carjacking that was not indicated here, as we do not have
it's okay.
I'm, again, nothing's been proven. I completely understand, but this there, as what was brought to my attention, is that did not take place because we do not have the owner of that vehicle, but those charges are likely to be added in the next week as well. Of course, his bond is based on just this case, and this case alone. We have somebody who had a weapon and ran from police and resisted orders from a police officer in a stolen vehicle, and therefore we do not believe any reduction should happen at this time. If it's so inclined, you can order a DSC report.
Okay, so, those charges, when they come, if they do, bond can be adjusted based off of that. I'm not going to consider cases that could be charged that may not be, I don't know. So in my understanding, Mr. Lenore, you cannot afford $1,000 to post bond? No. Mr. Lenore, if you don't mind me asking about his employment prior to arrest?
No, I don't check.
Okay, Mr. Lenore, were you employed before you were arrested?
Yes, ma'am.
Where?
Lazy boy, furniture.
Lazy Boy?
Yes, ma'am.
I'm serious. He said Lazy Boy Furniture.
Lazy boy.
And you no longer have that job? No. Okay. So I will adjust your bond over the people's objection, but you have to wear a tether. You're gonna be on house arrest and only allowed to leave for court and any medical appointments you have. In the event somehow that you have gained employment, you need to contact your attorney. She will Zoom and we can discuss any different changes in house arrest with proof of employment and verification. But at this time, house arrest with only leaving for court and for verification. Understood? And if you are leaving for medical report, you are not to be driving. I'm sorry, you hear that last? You're not to be driving. Okay. Okay, anything else? And just so you know, you may notice already, it may take us a week. That's, I don't have control over the tether unit to say it's about a week for a week.
Yes, ma'am. Thank you.
Attorney Dots?
Yeah. Good morning to the court.
Good afternoon.
Good afternoon, yes.
Good morning.
Every year, we're all the energy, we're so tired.